Okay, so in the ongoing litigation between Justin Baldoni and Blake Lively, a recent filing in the case indicates that Lively is trying really hard either not to be deposed at all, or at the very least, not by Baldoni's big bad lawyer, Bryan Freedman. And if the way that Baldoni's lawyers are portraying this whole issue is true, there are a number of issues here for Blake Lively. Let's get into it. Okay, so for those who don't know, Lively and Baldoni worked together on making the movie It Ends With Us, and while things may have started out well with production, things eventually went off the rails. She claims that he sexually harassed her and then retaliated against her for complaining about the harassment. Meanwhile, he claims that she made up the harassment and retaliation claims after her efforts and those of her husband Ryan Reynolds to basically steal this movie right from under him eventually failed. If you want to see more background on this case, check out my first video on the subject, linked in the description below. Now, I didn't go over all of the details in this long and winding story because there is just so much to go over, and it would require like at least a 2-hour-long video to break basically everything down. But it does give, at least in my opinion anyway, a fairly good introduction to this overall case. Anyway, beside the substantive claims and the evidence that's being made basically public on a daily basis here, there's also a battle between the two sides within the process of litigation. And this is kind of just the nature of litigation. This is how things typically happen. There is a battle between the two sides. It's not a process of diplomacy. It's meant to figure out who's right and who's wrong and who wins and who loses. And one of the ways of figuring all of that out is the discovery process. This is where both sides demand all kinds of information from one another through document requests, through questions in an admission denial format, open-ended written questions, and of course, what most people are familiar with, the deposition. This is where a witness generally comes to the opposing counsel's law firm, sits at a really big table right in front of a court reporter, maybe even gets videotaped in the process, and has to basically sit for hours getting grilled by the other side. The witness will generally have a lawyer representing them in the deposition as well, but honestly, there isn't all that much that their lawyer can do to stop the witness from having to answer questions unless those questions are way outside the bounds of what's allowed. And what's allowed is a lot. You see, the American judicial system believes very, very strongly in allowing robust discovery so that both sides can have a full opportunity to litigate their cases. So what does that really mean? That means that the standard for what can be requested in discovery and what they're entitled to receive is pretty low. Baldoni's team can request from Lively and vice versa, not only evidence that they think will be admissible at trial, but also evidence that they think will lead to evidence that will be admissible at trial. This means a lot, including basically all of the communications about production, and not just between Lively and Baldoni and other people who were officially working on production. This means a lot of information, to include communications that Lively has had with basically anyone about the production of the movie, to include her BFF Taylor Swift, who Lively has referenced multiple times as someone that she talked to often about the production throughout the entire process. And this means Taylor Swift can also be deposed because she's potentially a witness to a lot of things. Now, there likely will be a fight over whether Baldoni's side is entitled to communications between Lively and Reynolds, however. That's because they are married and therefore they are entitled to assert the marital privilege. This means that any communications made between Lively and Reynolds while they're married, which they currently are and have been for a while, definitely throughout this entire production, but communications also made with the intent that they be private and in reliance on the sanctity of marriage, those communications are going to be protected from discovery by the other side. There are similar privileges for communications between a client and a lawyer, between a patient and a doctor, and between a member of a religion and a bona fide spiritual counselor. Now, aside from these various types of privilege, like I said, discovery is generally super, super broad in litigation. And this is one reason why I think anyone who is watching this whole series of events unfold can learn a thing or two about litigation in general. People often have this idea that they can file a lawsuit and just kind of pummel the other side with facts and reasoning. But the reality is that even when you should be the winning side, litigation is messy and chaotic. The moment you get yourself into a lawsuit, you subject yourself to factors that are way outside your control, partly because you have no idea how the other side is going to be responding. And things can spiral very quickly. And I have to wonder if Lively was aware of that or really took that to heart when she was obtaining her right to sue with her CRD complaint back in December. If not, I would think that she would be now. Anyway, so in this particular case, now that the lawsuits have been opened up and all defendants have been served their respective complaints, discovery can begin. And this is the case even though at the time of filming this video anyway, neither Lively nor Reynolds nor Baldoni has filed any kind of an answer or a motion to dismiss in response to those complaints. And there are a number of really good reasons why any party in a case, especially a case like this one, might want to jump on discovery immediately. First, there's of course the PR front, and getting ahead of publicity is always going to be better than having to try to catch up. Second, when it comes to litigation, it can give you a strategic advantage if you have all of your factual ducks in a row, while the other side is scrambling to respond to the complaint, and now all of a sudden they have all of these discovery requests that they have to respond to within a timely basis because there is only so much time that they have in order to respond to them. That is a lot of time and a lot of effort and a lot of man hours that has to be put towards all of that all at the same time. It's about putting the other side off balance so that you can continue to put pressure on them for perhaps a favorable settlement for your side. It might sound a bit cold and vicious, but that is the civil litigation game. It also means that the earlier you have all of the evidence, the earlier you can start writing a motion for summary judgment, or MSJ for short. The MSJ is a lot like a motion to dismiss because it's basically trying to do the same thing. The only difference is that with an MSJ, you're now getting to use all of the evidence that exists, or at least that you have, in order to argue to the judge that no reasonable jury can find in favor of the other side, and that as a result, the judge can and should end the case in your favor. But in this case in particular, we also have a more specific reason why it's advantageous to jump on discovery basically immediately. You see, here we have a case that is consolidated in the Southern District of New York. And in this district, they're subject to an administrative order that automatically refers almost all cases to mediation within 30 days of filing the answer. So that's even more reason for either side to want to jump on discovery immediately and before they filed an answer or a motion to dismiss the complaint. That's because if they're going to be required to go to mediation within 30 days of that answer getting filed, they're going to want to go in with as strong a position as possible. And you do that by gathering strong evidence. If going into mediation, you have evidence lined up that shows that you're the one that has the stronger case, you can then make the argument that if it goes to trial, you will win, and if the other side decides to draw it out in litigation, it's going to be super painful and super costly for them because you're just going to continue to put pressure on them throughout the litigation process. And all of that helps with mediating for a better settlement for your side. And this brings us back to the recent letter that Baldoni's team filed with the court about Blake Lively's deposition. So with that, let's take a look at it in detail. Here you can see it says, "Dear Judge Lyman, as counsel for collectively the Wayfarer parties, we write to advise the court of an issue that the Wayfarer parties wish to address at the upcoming conference of Monday, February 3rd, 2025. During a conference of the parties' counsel on January 30th, 2025, counsel for the Wayfarer parties requested the earliest possible deposition of Blake Lively. Counsel for Ms. Lively and Ryan Reynolds, the Lively parties, stated that their objection to the Wayfarer parties' lead counsel conducting the deposition of Blake Lively. Specifically, the Lively parties' counsel indicated that they object to Bryan J. Freedman personally taking Ms. Lively's deposition based upon unspecified statements made by Mr. Freedman. When asked to elaborate on the grounds for their objection, counsel for the Lively parties declined to do so. Counsel for Ms. Lively has made clear that Ms. Lively does not want Mr. Freedman to be the attorney who takes her deposition. We are unaware of any situation that would warrant the deposed party to have a choice in which attorney takes her deposition. Parties to litigation simply do not have the right to dictate which of their opponent's parties may or may not take their deposition or perform any other aspect of the opposing party's case. The Wayfarer parties respectfully submit that this important issue should be discussed at the initial pretrial conference pursuant to Rule 26F3C of the Federal Rules of Civil Procedure. Pursuant to the court's individual practices in civil cases, we respectfully identify this as an area where the parties do not agree and ask that the court address the matter at the February 3rd conference. We look forward to further discussing this matter at the initial pretrial conference scheduled for February 3rd, 2025. Respectfully submitted, Kevin Fritz." Okay. Now, a couple things here. First, we do have to keep in mind that this letter was, of course, written by Baldoni's lawyers, who gave their characterization of the conversations that they had with Lively's lawyers about her potential upcoming deposition. It could very well be that Lively's lawyers have a very different interpretation of what was said in those communications and what were Lively's objections to being deposed by Bryan Freedman. But that said, what they said about a deposed party trying to have a choice in which attorney takes their deposition is absolutely correct. I have been a licensed attorney for around 10 years now, and I have never heard of any witness being deposed having any choice at all as to who deposes them. Like, that's an insane ask. And the thing is, Lively's lawyers are very respectable, big firm lawyers who know what they're doing. So the fact that they are supposedly putting forward this argument where they're trying to get anyone but Bryan Freedman, or maybe no one, to take Blake Lively's deposition indicates that one thing is most likely. Given the caliber of her lawyers, I highly doubt that they had the bright idea to try to stonewall her deposition, because anyone even just fresh out of law school without having had any practice under their belt at all whatsoever would know that that's just not something that you can do if you are a party to litigation. What's more likely, in my opinion, is Lively may have told her lawyers point blank, just, I'm not doing a deposition with Freedman. And her lawyers may have told her, but you don't really have any say in that. You kind of have to do it. And she may have just said in response, I don't care. Tell the other side that I'm not doing it. In other words, Blake Lively might actually be what is commonly referred to in litigation as a nightmare client. A situation like this can be tricky because on the one hand, every lawyer is supposed to counsel their client on what they think is the best course of action under the circumstances. And something as basic as taking a deposition like this should be an easy explanation, especially since she is the plaintiff in at least one of these cases, and she was the first to bring this whole mess to litigation. Now, for starters, any defendant is also going to have to sit for a deposition if the other side requests it. But when it's the plaintiff that is trying to get out of it, courts are going to be especially judgmental because they're the one that dragged the defendant into court in the first place. You can't drag them in and then try to say, oh, no, not me, leave me alone. So my guess is that a request that is as crazy as this one was not concocted by Lively's lawyers. Rather, this does seem like the kind of situation where her lawyer needed to just take a deep breath, put on the clown makeup that every litigator needs to put on at some point in their career, and make the request that your client is asking, even though they know that it's ridiculous to ask. And here's the thing. I said in my last video that I am not Team Justin and I'm not Team Blake. Not at this stage anyway. I know I do tend to be slow in coming to a side in a lot of these cases, but that's because I really do try to keep my head and consider all sides and every devil's advocate position as much as possible before coming to a conclusion. And I always reserve my right to change my mind when new facts come out, because that's the meaning of a fact-based analysis. But aside from the question of whether the evidence that exists in this entire universe of facts backs up one side or the other, this does appear to be a score for Team Justin, at the very least on the PR front. And truthfully, my guess is that in the litigation front, that's also going to be a win for them as well. On the PR side, this appears to be added evidence in the ever-growing social case against her being this mean girl who is trying to control and manipulate all of the people around her. And when that's the image that you're fighting against, that is continuing to grow and grow and grow in the public sphere, making an unreasonable request like this in a very public lawsuit is not helpful for your side. And it also is, in my opinion anyway, a show of weakness for Lively on the litigation front as well. Assuming that this letter characterizes the issue correctly, of course. This shows, to me anyway, that she's afraid of being deposed by Bryan Freedman. And truthfully, there could be a lot of reasons for that. Depositions in general are scary. You're in the hot seat, and if you say the wrong thing, you could potentially blow up your entire case, or at least there's always a fear that something like that could happen. And that fear is understandably there, even if you have a good faith belief without ego that your side is in the right. And if you've seen Freedman's interviews and his work in other cases, you know that he is a particularly intimidating lawyer too. He's a very well-known Hollywood lawyer with a long client list of well-known celebrities and a reputation for being being an especially tough litigator. And even in the limited amount of time that this litigation has existed in the public sphere, he very clearly has already shown himself in this particular case to be a total pit bull of a lawyer. So on the one hand, I get it. I wouldn't want to be deposed by him either, to be completely honest with you. That said, like I said before, when you're a party to litigation, you have zero choice. If the other side wants to depose you, whether you're the plaintiff or the defendant, you're getting deposed, like it or not. And one of the last things that you want to do, especially as a plaintiff, is to show that you are afraid of getting grilled on the claims that you decided to come forward and make to the public. And that's because at the end of the day, the plaintiff is the one with the burden of proving their own claims. And let's face it, lawyers are sharks. And once they smell blood in the water, they are alerted to that there is something tasty that you are trying to hide. So all in all, this latest move appears to be yet another misstep by Team Blake. I don't know why it keeps happening, but it seems that they keep stepping on landmine after landmine in this entire litigation process. Maybe things will change. Maybe they'll find their footing and start swinging back in the PR game and the litigation game alike. But for now, those missteps are doing them zero favors in either realm. But those are my thoughts. What do you think? Do you think this is an indication that Lively is afraid specifically because of the fact that she knows what evidence is out there? Or is she just afraid because Freedman is admittedly a big, bad, scary Hollywood lawyer? What do you think overall about the case on the PR front and the litigation front? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you would hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases like this one and interesting legal topics like this one, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. And if you're really enjoying the content and you want to know how to best support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next video.